All right, well, we'll switch some attorneys here now. All right, our next case is Ruth LEDOUX-NOTTINGHAM versus Jennifer and William Downs, case 14944. Counsel, whenever you're ready.
Yes, good morning.
Good morning.
May it please the court.
Yes, ma'am.
My name is Leanne Miller, and here with me today is Jamie Moses and our client, Ruth LEDOUX-NOTTINGHAM, the appellant and cross-appellee, and the mother of the 2 minor children at issue. I would like to reserve 5 minutes of my time for rebuttal.
Okay.
Though I am prepared to address both the issues on direct appeal and cross-appeal, I will be primarily focusing my argument on the direct appeal. Would your honors care for a brief recitation of facts, or shall I proceed directly to the argument?
Probably proceed to the argument.
Thank you. Your honors, the issue before this court is much more simple than the briefs would allow. Quite frankly, Florida law and public policy is clear, and indeed, appellees concede such on page 10 of their amended answer brief. Mandated grandparent visitation directly contravenes Florida law.
In essence, you need for us to rescind or recede from Bellow.
No, Your Honor.
No?
Your Honor, Bellow is distinguishable for 2 reasons. Pursuant to this court's holding, the 5th District Court of Appeal is currently not in accord with the 2nd and 4th District Courts of Appeal. However, Bellow is distinguishable. First, the court in Bellow addressed the case as a time-sharing case pursuant to Chapter 61.
Well, let me make sure I'm clear, though. I thought in your brief you acknowledged that our decision today might be controlled by our decision in Bellow. Did you say that, or wasn't that the...
Yes, Your Honor, that was in my brief. However, pursuant...
Is that not your position anymore?
No, Your Honor. Yes, this court is controlled by Bellow. However, Bellow did not reach the subject of modification. It conceded that the judgment, the Louisiana judgment at issue, needed to be both domesticated and enforced pursuant to the full faith and credit clause.
If we believe that Bellow is applicable, do you not want us to certify conflict with MJ?
Your Honor, if you believe that Bellow is applicable and that you are confined by it, then yes, we are requesting as alternate relief that you do certify conflict not only with the 4th DCA in MS versus DC, but also the 2nd DCA's more recent case of 2012 of Fazzini versus Davis. Notably, in Fazzini versus Davis, which this court did not have the benefit of when examining the case in Bellow or in the subsequent case of Shingle versus Peters, in Fazzini versus Davis, the 2nd DCA first identified that these type of cases should not be addressed or analyzed pursuant to Chapter 61. Chapter 61 addresses issues of time sharing between parents, not parents and grandparents. Secondly, Fazzini then went on to provide that there are 2 ways in which sister state judgments may be modified. One, pursuant to the overlying public policy and law of Florida stating that grandparent rights are not recognized, or 2, subsequent to the modification, if indeed it does fall into a Chapter 61 status.
In Fazzini, didn't the trial court find grounds for modification? I mean, this traditional grounds, if it was solely a Florida case, you have to want to modify a time-sharing plan. They made findings, or the trial judge made findings in Fazzini. I understand the overarching thing is the constitutionality of grandparents having court-ordered visitation, but they also found that there was this change in circumstances.
Correct, Your Honor. Fazzini dealt with a Connecticut judgment. However, the trial court, it's worth noting, found specifically that as a threshold matter, that it ultimately reversed the trial court due to the public policy of Florida, which completely subordinates grandparent visitation rights to the superior rights of parents. That is on page 103 of Fazzini. It also went on to analyze it pursuant to the substantial change of circumstances test in Wade v. Hirschman, as Your Honor recognized. However, it did so because the trial court applied the incorrect standard. So in doing so, the second DCA not only used it as a vehicle to clarify the substantial change in circumstance test should it be a Chapter 61 case, but also address the fact that the full faith and credit clause does not trump the fundamental liberty rights guaranteed to parents by the Florida Constitution and the federal Constitution.
Let me ask, just so I'm clear what some of the in the brief, you're indicating you did not challenge the jurisdiction of the Colorado court to enter its final order awarding the grandparents' visitation privileges.
Correct.
You're still with that?
Your Honor, that was an argument that we did concede and we did not address on appeal. That was an argument that was, and an issue which was quite contested at the trial court in Colorado.
Now.
Correct.
Not changed your mind about that?
No, Your Honor.
And you're also not contesting the domestication of the Colorado order under the full faith and credit clause?
No, Your Honor. As the 4th DCA pointed out in MS versus DC, sister state judgments are entitled to domestication and recognition pursuant to the full faith and credit clause based on comity principles. However, it goes one step further. While a judgment is entitled to recognition and domestication on comity principles, the question then becomes, is it subject to enforcement based on the fundamental liberty rights that Florida recognizes specifically for parents? And if so, is it then subject to modification to terminate grandparent visitation rights? Both the 4th and the 2nd DCAs have unequivocally found so. And indeed, when this court certified conflict between Shingle versus Peters, relying on its former precedent of Bello versus Bello and MS versus DC, the Florida Supreme Court accepted certiorari of that case.
Well, let me ask this. So it can be domesticated, but it can't be enforced. Then what's the point of the domestication of it, of the judgment?
Based on comity principles, Your Honor. And our argument is actually twofold, Your Honor, that it shouldn't be enforced pursuant to the full faith and credit clause because it violates the public policy, but even if it is enforced, it's then subject to modification. And that's precisely what the court in Fazzini versus Davis was saying, and the reason why this court has the opportunity to harmonize the districts, because in Bello versus Bello, this court didn't have the opportunity to address that modification standard.
Why not?
Your Honor, we were unable to get those briefs. We don't know if those issues were briefed or indeed an oral argument. It appears that only one party was represented. So we're unsure why the court did not do so. It could also be, again, that the only other precedent at the time directly on point was MS versus DC, and since that time, Fazzini versus Davis, decided in 2012, went through and very explicitly stated, and it is our belief that because of the issues happening across the country today, not just in grandparent visitation, but specifically in the same-sex marriages and adoptions, as Appley's referenced in Henry versus Himes, that the 2nd DCA felt that it was important to specifically instruct the courts as to how you can modify a judgment pursuant to full faith and credit, particularly when that judgment violates the public policy of a state.
Well, I understand the public policy argument. I'm looking at a U.S. Supreme Court case that I guess I'm having a hard time understanding how it does not apply here. I mean, it talks about the full faith and credit clause does not compel a state to substitute the statutes of other states for its own statutes dealing with a subject matter concerning which it is competent to legislate. Regarding judgments, however, the full faith and credit obligation is exacting. A final judgment in one state, if rendered by a court with adjudicatory authority over the subject matter and persons governed by the judgment, qualifies for recognition throughout the land for claim and issue preclusion purposes. In other words, the judgment of the rendering state gains nationwide force. A court may be guided by the forum state's public policy in determining the law applicable to the case, but our decisions support no roving public policy exception to the full faith and credit due judgments. Assuming the existence of a ubiquitous public policy exception permitting one state to resist recognition of another state's judgment, the district court wrongfully concluded the full faith, the Supreme Court concludes the full faith and credit clause is one of the provisions incorporated into the Constitution by its framers for the purpose of transforming an aggregation of independent sovereign states into a nation. It seems to me that the U.S. Supreme Court is saying if it's an application of a law of another state that violates our public policy, that's one thing. But once a judgment is lawfully entered in a different state that had the authority to make that judgment, we can't just simply say, that flies in the face of our Constitution, so forget about that full faith and credit clause of the U.S. Constitution. That seems to be what you're saying. Tell me why I'm wrong.
Your Honor, I'd like to address your question on several points. First, would you be so kind as to give me the name of the case to which you're referencing?
Yes, ma'am. It's called Baker.
Baker versus General Motors Corporation, decided in 1998?
1998.
Okay. A few things that I would address. First of all, in the passage that you read from Baker, the court specifically addressed and referenced resisting recognition. We are not resisting recognition of a sister state judgment in this case. And furthermore, there is another Supreme Court case, that of Follett versus the Town of McCormick, 67 Supreme Court 717, in which it does discuss, albeit in somewhat loose language, it doesn't explicitly state it, but it does discuss a constitutional hierarchy of liberties. And those fundamental liberties, which are so guaranteed, particularly those liberties inherent within the First and the 14th Amendment, cannot be taken away less than a compelling state interest. And this brings me actually to my second point. This is not only an issue of Florida law, Your Honors. This is also an issue of federal constitutional law. The 14th Amendment of the federal Constitution grants parents a fundamental liberty interest in the care, custody, and management of their children. And federal constitutional jurisprudence has consistently protected the right to child-rearing autonomy. This federal constitutional guarantee of a fundamental liberty interest is further extended by Florida's state guarantee of privacy. Article 1, Section 23 of Florida's Constitution states that every natural person has the right to be let alone and free from a governmental intrusion into the person's private life. This grants parents an explicit privacy right of child-rearing autonomy, which may not be intruded upon by the government absent a compelling state interest. The case to which you cited, Your Honor, is not dealing with this specific circumstance. It might be dealing with a sister state judgment, but it's not dealing with a sister state judgment that intrudes upon fundamental constitutional liberties that are not only guaranteed by Florida's Constitution, but also by our United States Constitution. Furthermore, when Florida has addressed this topic, specifically the Florida Supreme Court in Beagle versus Beagle, it discusses that this can only be intruded on with a compelling state interest. In this case, a compelling state interest is substantial harm to children. So you have to show that there is either abuse, neglect, abandonment, or sexual exploitation. The record does not reflect any of those facts today, such to justify that the state can interfere in Ms. LEDOUX-Nottingham's rights, fundamental rights to child-rearing autonomy. Furthermore, death of one or both parents does not constitute a compelling state interest such to render harm to the child. This was also addressed by the Florida Supreme Court in Von F. versus Von F. An enforcement of a sister state judgment pursuant to the full faith and credit clause does not constitute a compelling enough interest.
Let me jump back to Bello for a second. I mean, in your differentiation between domestication, which is permissible under the full faith and credit, and the enforcement, which you said violates Article 1, Section 23 of the Florida Constitution, in Bello, I mean, it seems this court indicated in its opinion, after it recognized the full faith and credit of the out-of-state, the Louisiana decree, it says a foreign judgment is not rendered unenforceable because it may violate a public policy of the forum state. So it seems in Bello we were saying that the Louisiana decree is enforceable here in Florida, that granted the visitation to the mother and sister of the deceased husband.
Your Honor, you are correct, the Bellow opinion does state that. However, I would also posit that nowhere in the opinion does the Bellow court discuss modification, and that is something where I believe that Fazzini versus Davis, not to beat a dead horse, I know we've talked enough about horses today, but Fazzini versus Davis is particularly instructive because it addresses all components of the full faith and credit clause, not only registration, domestication, enforcement, but modification. And by either not enforcing the judgment or enforcing it and then modifying it, either way will uphold the fundamental constitutional liberty interests which are currently at stake.
But I mean, at the time that Bellow was decided, Von Arce, I don't know how you say that case, the Florida Supreme Court case, not Von Arce?
Oh, Von F.
Von F.
Yes.
That was already decided, so why, it seems like this court could have simply said, you know what, there's a foreign decree, but Von F says it's not enforceable here.
Your Honor, actually, Von F did not deal with a foreign decree. Von F dealt with the death of one or both parents and then went on to talk about how the death of one or both parents did not constitute substantial harm. And indeed, this court in Belair versus Drew went on to further deem unconstitutional other portions of the grandparent visitation statute, Chapter 752. However, and I believe that this court, again, in Bellow, perhaps did not go into the reasoning as to the modification simply because there wasn't other case law on point. The only other case on point at the time was MS versus DC, decided the same year as Bellow, and indeed, when this court was presented with the issue again in Shingle versus Peters, those were still the same two key cases on point. So at that point, we had a split in the DCAs with really no explanation as to how to harmonize these two districts. I believe the second DCA in Fazzini versus Davis has done precisely that by showing this court and elaborating, not just to this court, but to all the districts, a way in which sister state judgments can be modified to comply with the fundamental liberty interests at hand. Fazzini versus Davis has now elaborated on MS versus DC, Bellow versus Bellow, and Shingle versus Peters, such that this court has the opportunity to harmonize these decisions by reversing the denial of the trial court's modification and terminating the grandparents' visitations rights. I would like to reserve the rest of my time for rebuttal, if I may.
Okay, thank you.
Thank you.
May it please the court, I'm Andrew Wendell on behalf of the grandparents who are not present but are watching from Colorado. Your Honors, I'd like to reserve 2 minutes for rebuttal for my counter appeal, if that would suit the court.
Okay.
Thank you. Now, what's interesting in terms of what we've discussed here today is that we've kind of missed on full faith and credit that the underlying issue of what's at stake really doesn't matter at all. If there's a judgment, as Your Honor has already pointed out, the Supreme Court has already ruled that that judgment is without exception for full faith and credit purposes. And there are different issues, as Your Honor has also pointed out, with law and what sort of full faith and credit they get. But in Henry versus Himes, the court in Ohio, the federal court, went through painstaking detail to issue a historical rendering of exactly how this came out. And once again, he elaborated that there are no exceptions whatsoever to full faith and credit, particularly for public policy, when you're dealing with judgments explicitly. Now, we actually go, this chain of cases with the 5th DCA actually goes one step further back than Bellow and Shingle. It started with M&R Investments. M&R Investments was a case that came to us from Nevada. There was a gambling debt, certainly something against our public policy. That gambling debt was then domesticated and sought to be enforced in Florida, or rather the judgment on the gambling debt that was obtained in Nevada. Florida court, the 5th DCA, specifically acknowledged that that was against our public policy, but found that there was no exception to the public policy provisions. And that was again upheld with the Bellow decision and again with Shingle. In all of these cases, the court was express and aware that it was against the state's public policy. It was nothing new or novel, and the conflict with MS versus DC came out, and that came out before Shingle, and this court, the 50CA in Shingle, addressed that MS versus DC expressly went against it and expressly found a public policy exception, but nowhere in MSDC did they ever address the U.S. Supreme Court case of Baker versus General Motors, or any argument about whether or not there should be exception. They simply said there was an exception. So in terms of what this court has done, it has been very clear in elaborating that we are not only going to domesticate, but also enforce. That word has been in all of the judgments, or excuse me, all of the opinions, rather. And the enforcement is critical here because it's really disingenuous to take the position that we're going to enforce, but if they ask for modification, all just evaporates. That we're going to domesticate, we're going to recognize it, but it's all just a showmanship. Again, has been seen in...
That's how you're reading their argument, that basically it's okay to domesticate, I guess you can enforce it, but we did not consider modification, and you can simply file and ask a request to modify based upon the public policy in Florida. Say public policy is that there is to be no court-ordered grandparent visitation.
Yes, that's how I interpret their argument. I also find a fatal flaw with that argument, and that would be found in two instances. First is 61.132C, which is the Florida statute for modification. And that statute specifically addresses the UCCJA. It specifically in that subsection is talking about the UCCJA and then lays out what's necessary for a modification. And in doing so, it's specifically recounting basically the statutory factors of enactment of the Wade standard. Now, in addition to that, I think even more telling, or if I might quote to you from Fazzini from a couple of places, because it's been argued that Fazzini takes the position that we're going to simply modify to conform with public policy, but that's not what Fazzini did. Fazzini strictly adhered to Wade. In fact, the court in Fazzini said, the court can find no case which suggests any legal standard for modification of time-sharing order other than a showing by the moving party that a substantial and significant change in circumstance of the parties must be first established by evidence, and only then can the court go to the second step of determining whether the modification is in the best interest of the child. That court went on to say, and I quote again, our guide in this case is Wade v. Hirschman, and went on then in painstaking detail to show where the trial court had erred in terms of finding a substantial change and where it was correct and supported in finding a substantial change, saying, Mr. Fazzini established that there has been a substantial and material change in circumstances since the entry of the Virginia judgment that was not reasonably contemplated, i.e. his remarriage, the step-parent adoption, and Ms. Davis's interference with Mr. Fazzini's parental decision-making. And then it goes on to say, but beyond, meaning, as I read, but beyond, meaning once you've met that threshold, then we go beyond that and look at the public policy. If you haven't met it, you don't go beyond, and that's where...
Doesn't that cause us some difficulty in certifying conflict with the Fazzini, since there's a factual finding that supports the modification?
Well, yes, Your Honor, there are actually two main issues with certifying conflict. First is that there is no reasonable basis in this case for a modification. The modification that was sought, again, I point out to the court, the modification was sought 4 months before the Colorado order or trial had even occurred.
Any modification has to be from the time the last order of time sharing until the petition's filed. So in essence, here it's a 13-day window.
Yes, a 13-day window in which they received the order, then they contemplated drafting a new petition and filing that new petition, 13 days, and then it's religious beliefs. Again, religious beliefs were already known before. These were foreseeable. The older child having grown and developed in 13 days, such that I think that it's pretty clear that modification in terms of substantial change has not been met. And so the two things that I would point out to this court is that, and again, and this is the conclusion also, is that Mr. Fazzini properly domesticated the Virginia judgment and sought to modify it based on a substantial material unanticipated change. And so it was that he did that and he met that burden. That has not been met in this case. And so there's not going to be a conflict because we never get to the point where the modification, the basis for modification has been proven. Fazzini is not a separate secondary standard. It is one and the same as Wade v. Hirschman. Now, the other issue that is created with considering certifying conflict again is that what's interesting is that all of this chain of cases, there has never been a showing of any discussion about the Parent Kidnapping Prevention Act. And unlike the UCCJA, which is a federal framework enacted by the states in their own state-level legislation, the PKPA is federal law. And as federal law, it comes with the weight and authority of the Supremacy Clause. And I don't think that anybody has ever argued that the Supremacy Clause is subject to exception, and it is the public policy of the United States of America that you enforce visitation of sister states. That is not optional. That is the PKPA.
But you don't, your opponent seems to argue that Article 1, Section 23 of the Florida Constitution gives these parents the right to not have interference from the government, i.e. through the court-ordered grandparent visitation. You're saying that that does not trump the full faith and credit?
Well, absolutely not, Your Honor. The Supremacy Clause dictates that even the PKPA as a federal legislative act trumps the Florida Constitution. And I would point out that Troxel, which is a U.S. Supreme Court case, kind of the seminal case on grandparent and third-party contact, is expressive in saying that we would be hesitant to hold that a specific non-parent visitation statute violated the Due Process Clause as a per se matter. And this really turns into a collateral attack is what it turns into, saying that we have a violation of a constitutional right here. Well, if there was, that should have been taken up in Colorado based on whether the law was or was not valid. But now we're in Florida. It's no longer subject to collateral attack, and as a result of that, we're left with the issue of dealing with, first off, full faith and credit. There is no exception for Florida public policy. So in that argument, the public policy vis-a-vis the state constitution is irrelevant. With PKPA, the federal mandate to enforce this comes in and says, you know, it doesn't matter if Florida Constitution is different because the Supremacy Clause, it's a higher right. And then, of course, the highest is the federal Constitution in full faith and credit, which has been discussed numerous times in the cases that have been provided in the brief, but is the fabric which weaves our society together. I mean, there's historical resuscitation going back to the First Continental Congress and how our original government was inoperable because of the fact that there wasn't a bond between the states to form a solid union. And that is the fabric which weaves our country together, which makes all states into one union. There is perhaps nothing more sacred to our country than creating that bond. And so I suggest to the court that as we deal with this matter, that certification is not necessary because, again, for the numerous reasons I've given on Fazzini not being in conflict, but also because of the PKPA, which has not been addressed at all as a completely independent basis. And if we get to a point of a certification of conflict, and there are two independent bases, one being full faith and credit, the other being the PKPA, and the Supreme Court's only going to hear what's certified, and the only thing that's in conflict is one issue. If this can stand alone independently on PKPA, it makes the certification moot. I would also point out to this court that we have an interesting distinction here in terms of public policy, because the public policy of Florida, through Chapter 752, the Grandparent Rights Statute, through Chapter 61.13002, a military right that allows you to give time sharing to grandparents while you're on active service, adoption and dependency statutes that allow favorable treatment to grandparents. There is no public policy against grandparent time sharing. That's the what. What was at issue in Beagle and Von Eff and these other cases was the how, the intrusion upon the Florida state constitutional rights. And what they were dealing with was not that grandparent having contact is bad, it's grandparent having contact and how that then encroached on this privacy issue. Now the how is critical because, again, we get to collateral attack. We're not dealing with how Colorado did this because their jurisdiction was appropriate and they are no longer subject to collateral attack from the state. That's what the appellate rights in Colorado would have done that were not pursued by the mother. So as a result of that, I believe that we do have this issue of what actually the public policy is, but I don't believe we ever have to get there. Now, in addition to that, I'd like to point out that with respect to these other issues that were taken up on our counter appeal, we had two other issues. There was make-up time sharing and there were attorney's fees.
Well, as to the makeup timeshare, I know the judge elected not to hold the mother in contempt, but he also specifically indicated he was reserving jurisdiction as to makeup timesharing. So why is that not ripe here? And you just, if we remand this, just have a hearing on makeup timesharing, irrespective of an adjudication. It sounds like the trial judge believed that the mother was acting in good faith based upon her belief that court-ordered visitation, grandparent court-ordered visitation is not enforceable in Florida, so she chose not to honor the Colorado court order, and the Florida trial judge elected not to hold her in contempt. But to me, that's apples and oranges. There's still time sharing that he did not address, and he specifically put in his judgment, I reserve jurisdiction. So how is that really ripe for us?
Well, I think the issue that we've run into is that ultimately we made the request and we were at the point of a directed verdict. So this was a one-day trial, because I was unfortunately trial counsel for this, so I have a very good insight into this. A directed verdict was granted, and that was it. We were 3 hours into the day, not even, and we had more than 3 hours remaining. The request was made for it to be heard, and it was not allowed to be heard. And then there was a statement that the mother subjectively felt that the children's best interests were observed. But the problem with that is that, of course, there was not, the Colorado judgment specifically said the best interest was the visitation.
But the Florida judge did not deny your request for visitation. He just denied a portion of that request not to adjudicate the mother in contempt, and that seems to be a discretionary call on his part. That's not really an abuse of discretion.
Well, I do agree that contempt is a discretionary power to be implemented as the trial court sees fit in most instances. There are other issues besides contempt at play for that, and one in such instance is the enforcement. The enforcement is required, and the problem is that you can't kick the can down the road, because if the trial judge says, I'm going to reserve, even though I have time, even though I've heard this all today, even though it's been 15 months and there hasn't been any order allowing the mother not to extend the time.
Right, but that's why I would assume under your scenario you would want it to go back to have the trial judge grant makeup visitation.
Yes, Your Honor.
But he hasn't denied it, he just didn't address it.
Yes, and so we very much want that issue to be pointed out as something that remains intact to go back and to be
But there's been no error in his ruling because he's not made a ruling for appellate purposes.
Yes, Your Honor. Okay. Thank you for clarifying that point. Yes, Your Honor. And with respect to attorney's fees being the last issue before this court, the UCCJA has a prevailing party attorney's fees provision. That's statute 61.535. And in part, it uses the words that the court shall award. And then it goes on to say, unless clearly inappropriate.
So you believe the trial judge did not apply, there's nothing in the record indicating the trial judge applied that standard, and so you're asking us to send it back to decide whether it would be clearly inappropriate or not to award attorney fees.
Actually, Your Honor, I'm asking the court to go one step further and to indicate that attorney's fees should have been awarded here because of the fact that we already have a concession from the mother that there was, in the 15 months, there was none of the time afforded. And the whole purpose, and I've cited case authority for this, is the whole purpose of this prevailing party fee provision is to ensure compliance, is to ensure that people are going to conform with the orders. And the mother just thought optimistically, oh, I come to Florida, I get this thing turned around. Well, you know, she'd been presented with the memo of law showing Bello.
Shouldn't we let the trial judge at least decide, listen to the evidence as to why, and then render a decision as to whether it was, I award attorney fees to the grandparent, or I understand I can award attorney fees to the grandparent, but I find in the circumstances of this case, A, B, C, D, it would be under the statute clearly inappropriate to do so, therefore I deny it. At that point, then the statute has been applied, whether it's been applied correctly or not, can then be addressed if your clients deem it appropriate to raise that on appeal. But you know, right now, he just summarily denied, the judge just summarily denied it, and there doesn't seem to be an indication in the record that that analysis was done.
No, I don't agree that the analysis was not done. I think that Your Honor is very astute to that point, because given that it was a directed verdict and given that the judge at that time was unwilling to hear anything further on the case, the analysis was not done at that time. And if the record, which I believe that Your Honor is kind of implicitly indicating, is not ripe enough to show a full-fledged argument on that.
But it's a little different than your last argument, because there actually is a determination here.
Yes.
He says you each pay your own fees, and you had a fee request.
Yes, Your Honor.
And there's not an indication, since you're the prevailing party, for lack of a better term, there's not an indication that the judge, in the record, that the judge made the analysis saying, I am denying this request, your grandparent request for attorney fees, because I think under the facts of this case, it's clearly inappropriate. At that point, then we would look at it as an abuse of discretion or not.
Absolutely, Your Honor. I agree with that this would be distinguished in that there would be a remand for the correct legal standard to be applied versus the other scenario of make-up time-sharing, where it would simply be that, that's reserved and, the court can get to that when it's brought to their attention and they have the opportunity to do so. Yes, Your Honor. And if it would please the court, then I will reserve the remainder of my time for rebuttal.
Very well.
Thank you.
Okay, counsel, are you ready?
Give me just one moment, Your Honor.
Yes, ma'am.
May it please the court?
Yes, ma'am, go right ahead.
As to the direct appeal, Appley's argument is flawed for several reasons, not the least of which is a misstatement of the law. The case upon which Appley's rely, Henry versus Himes, not only the provision to which they cite is a footnote in dicta. The case was decided as to equal protection and due process clause. Indeed, the court did not need to reach any discussion of full faith and credit clause. Notably, however, that case has been expressly overruled by DeVore versus Snyder at 772 F. 3rd 388 in November of 2014. This was filed in our Notice of Supplemental Authority about 2 days ago. Notably, that court, the Sixth Circuit, stated, the plaintiffs in these cases do not claim that refusal to recognize out-of-state gay and lesbian marriages violates the full faith and credit clause, the principal constitutional limit on state choice of law rules. Wisely so. The clause does not require a state to apply another state's law in violation of its own legitimate public policy. Your Honor, that's precisely what we have today, and this indeed is the most recent federal law on this. Additionally, Appley points to Troxel as a seminal case. This is indeed a seminal case on grandparent visitation, but it supports appellant's position. It states that the due process rights of the mother were violated by a statute which mandated grandparent visitation. Further, Appley points to several alleged flaws in our arguments. Namely, they point to the UCC-JEA mandating that custody agreements between states be recognized and the PKPA. However, the UCC-JEA applies to Chapter 61 proceedings. As I have already indicated, this is not a Chapter 61 proceeding because this is not between parents and parents or guardians of children. This is between parents and grandparents, to which Chapter 61 does not apply. The PKPA does mandate that states give full faith and credit to child custody determinations made by sister states. Again, we would posit the PKPA does not apply because it's not a child custody determination. However, if it did apply, it does provide a provision for modification, 28 U.S.C. 1738F, stating that a court of a state may modify determination of the custody of the same child made by a court of another state if it has jurisdiction to make such a child custody determination and if the court of the other state no longer has jurisdiction. It's undisputed that at the time that Ms. LEDOUX-NOTTINGHAM filed her amended verified petition, the Colorado court no longer had jurisdiction, and indeed jurisdiction had vested in the Florida court. In fact, counsel for Appellees admitted Colorado had relinquished jurisdiction and Florida was a minor children's home state in the January 13, 2014 proceedings. And that's in the record at page 451. However, if indeed the only way to modify is through the substantial change in circumstances test, one of the key overlooked substantial change in circumstances was the move to Florida. Your Honor, Judge Lambert, you pointed out that only 13 days had lapsed in between the judgment and the amended petition. However, in doing so, the Colorado court failed to address the impact of the Florida law on any part of its order. It was aware of the state proceedings in Florida as found in the record on page 382. The implication is quite simply that the Colorado court knew that it was relinquishing jurisdiction at the conclusion of the order, new proceedings were at issue, and decided to allow the Florida court to examine the order. As to the cross appeal, they lose as a threshold matter because this is not a Chapter 61 issue. However, even if this court decides Chapter 61 governs, the mother did indeed believe in good faith that she was entitled to constitutional liberty protections, and as such, she has complied, however, during the pendency of appeal with the visitation. I see my time has expired, so we would request that this court reverse and terminate the grandparents' modification rights or certify for conflict. Thank you.
Thank you, ma'am. Hang on, let me see. Okay, I'll give you 3 minutes.
May it please the court?
Yes, sir.
Thank you, Your Honor. Okay, so I'm going, unless asked otherwise to do so, I'm going to constrain this discussion to just make-up time, share, and attorney's fees, as that's the rebuttal points for which I feel that I'm appropriately entitled to speak to.
Yes, sir, thank you.
I would point out to this court that with respect to this issue of make-up time, that with regard to express clarification to the court that they did reserve and that we can come back around to that issue. I'd also point out to the court that excuse me, with respect to the attorney's fees provision in that prevailing party award, that again was found in 61-535, which both the make-up time and the fees provision, what we're using as the basis for that argument is the fact that Chapter 61 encompasses the UCCJA in its entirety. All of the UCCJA is found within 61, and so as a matter of make-up time and fees, those are clearly 61 proceedings. The make-up time actually says Chapter 61.526, and it allows for any remedy available. Any remedy available is found in that statute in terms of how you can enforce these visitation rights. Any remedy available, and so certainly that include the other remedies found within Chapter 61. Likewise, when we look at the definitions within Chapter 61, we see this notion that Chapter 61 specifically contemplates other people acting as parents. That's within the definition structure. And within Chapter 61, Part 1, there's actually definitions which then indicate that a parenting plan is a child custody determination, showing the interplay between Section 1 and Section 2. And that's how we get into 61.134C1, that's a mouthful, which allows that the court shall provide the make-up time. So essentially, if there needs to be any clarification for the trial court on that point, that's what I would point your honors to with respect to that. And with respect to the attorney's fees, of course, again, it is a Chapter 61 proceeding, and that it's 61.535 that governs this particular aspect of the case. And so it would be with instruction, my hope would be that it would be with instruction to the trial court to take a look at that particular fee provision as part of Chapter 61. And likewise, I will refrain from getting into any of the other arguments, so I do thank the court for the time today.
Thank you, counsel. All right. Thank you, counsels, for your argument. Very interesting issue. We'll stand adjourned.